Mr. Goodar, delegates. My name is Jonathan Morrall. I work for Kilburn and Strode LLP in London. I've been in the patent profession for 8 years now. Before then, I was actually a software engineer myself, so I've done both the engineering side and now the patenting side of things. My day-to-day practice is in electronics, physics and IT, and I have experience of European hearings, appeals, oppositions, etc. So today, here we go. So today I'm going to be talking about software inventions and comparing the EPO and the UK IPO's approaches. So for the EPO, we'll just take the sort of the legal basis first. There's basically two hurdles you have to meet. Firstly, is your subject matter inherently patentable? And secondly, do you actually have an inventive step? Do you meet that invisible threshold? And after discussing that, we'll also talk about 5 landmark decisions that have really honed how the EPO approaches this sort of subject matter. So firstly, according to the EPC, European patents shall be granted for any inventions in all fields of technology, provided that they are new and they involve an inventive step and are susceptible of industrial application. So for the first hurdle, it's any invention, but then that's qualified by a series of exclusions. And as you can see there, paragraph 2C, programs for computers are excluded. And then paragraph 3 goes on to qualify that relating to the subject matter as such. But actually, the way that the EPO case law has developed, they tend to really concentrate on whether your invention is technical rather than it actually is a computer program as such. The second hurdle is, of course, inventive step. Now, at the EPO, they have a 5-step test, which they call the problem-solution approach. So the first step, then, is what is the closest prior art? What is the most promising starting point for the notional skilled person? This isn't necessarily the document with the most features in common. It could be a document that's in the same field, directed towards the same aim, with maybe a few less features in common. After that, obviously, you talk about the difference between the claim and the closest prior art. What are your novel features? And then you need to think about the technical effect caused by this difference. And then what is a technical problem and therefore what is a technical problem underlying the claimed feature? What technical problem are you attempting to solve? And when you've done all of that, you then have to think about, would the skilled person solve this problem in the manner claimed on the basis of the totality of the prior art without inventive skill? So there's some terminology there, and in practice the EPO imports its technicality considerations into its inventive step analysis. So for example, if we think about a wheel, it makes something movable. So the technical effect of the wheel is that it's making it movable. The technical problem, i.e. how to provide the technical effect, could be considered to be how to make the item movable. And that's really how the EPO would approach this. Although, of course, technical is not defined, and so we have to then look to case law for that. Moving on to software, it would be particularly difficult to show that an invention is technical when it is primarily a computer program for performing one of the other exclusions, for example, mental acts, doing business, or presentations of information. So really the key point is that the EPO grants patents when a non-obvious technical solution to a technical problem can be identified. So I'll move on to the case law. As mentioned previously, there's 5 landmark decisions, the first one being almost 30 years ago now. And then only 3 or 4 years ago, there was a referral to the enlarged board, which it didn't really answer anything, although the enlarged board did decide that it considers practice in this area to be fairly settled, but it doesn't consider there's been many divergent or any divergent decisions. So as we'll see, after the Hitachi decision of 2004, the EPO's approach has been pretty consistent. So in '86 then, Vicom. So this was one of the first cases that established the key principle that computer-implemented inventions are inherently patentable. The subject matter concerned a computer-based digital processing of images using a particular underlying mathematical technique. And the method, and the claim was basically a method for digitally filtering data. And this was considered to be a mathematical method, which is basically carried out on numbers, and therefore it was too abstract, and that wasn't allowed. The claim was reformulated into a method of digitally processing images in the form of a 2-dimensional data array. And that was basically allowed. I'll give the reasoning on the following slide. And so this case basically clarified the boundary of the mathematical exclusion. So the reasons for the decision in Vicom, as it says on the slide, even if the idea underlying an invention may be considered to reside in a mathematical method, a claim directed to a technical process in which the method is used does not seek protection for the mathematical method as such. And a claim directed to a technical process which process is carried out under the control of a program, whether by means of hardware or software, cannot be regarded as relating to a computer program as such. And furthermore, the subject matter was deemed to be technical and have a technical effect. The decision was that the invention furthermore confers a technical benefit, namely a substantial increase in processing speed compared with the prior art. Moving forward to 1998, this IBM case, and this basically determined that you can have claims to computer program products. So the method and apparatus claims were found allowable at first instance, but the appeal was to do with whether claims to computer program should be granted, should be allowed. And basically the take-home point from here is that a computer program product is not excluded from patentability under the EPC if, when it's run on a computer, it produces a further technical effect which goes beyond the normal physical interactions between a computer or between a program, software and a computer hardware. And basically, whether a computer program is claimed by itself or as a record on a carrier, the EPO doesn't care about that. So what I'd recommend is in the description, you make clear that the medium can also be a signal. And this is in contrast to the approach by the US, where they would have the non-transitory limitation, which we wouldn't need at the EPO. Moving forward to year 2000, we had the pension benefits system concerning the allowability of a technique for controlling a pension benefits program by administering subscriber-employer accounts in a particular way. Now, I'm not going to read all of this slide, but basically in this case, the method claim was found to be excluded. Now, the EPO has moved on from this approach, but at the time, the method claim was excluded. But the apparatus claim was patent eligible. It wasn't excluded, and that's because the apparatus claim recited a computer system. However, the claim was, in the end, rejected for obviousness, and the second paragraph there gives the reason why. When running the problem-solution analysis, the non-technical innovation, i.e. in this case the pension scheme, can be given to the skilled person, i.e. the programmer, as part of the technical problem that he needs to solve. A computer directed to that particularized scheme is an obvious answer to this question. But the important take-home point from here is that patent eligibility question has been brought into the assessment and inventive step, and this is the mainstay of current EPO practice. Moving forward to 2002 in the Convict case. Now, this is the case where the EPO included non-technical parts of the solution into the technical problem. So briefly, this case was to do with a digital module telephone system and use of a single-user multi-identity IC card, SIM card. And the claims had the following novel features. Number one was subscriber identity module was allocated at least 2 identities. Number 2, the identities were selectively usable. And 3, the selective activation was used for distributing the costs for service and private calls or among different users. Now, the crux of this is halfway down that paragraph on the left. In particular, where the claim refers to an aim to be achieved in a non-technical field, this aim may legitimately appear in the formulation of the problem as part of the framework of the technical problem that is to be solved, in particular as a constraint that has to be met, i.e. a form of software specification. So therefore, features 2 and 3 were deemed non-technical and they were imported into the problem, and the remaining features deemed obvious based on the cited art. Moving forward to 2004 and Hitachi and the auction method. This was to do with an automated auction executed on a server computer. The invention was claimed in both method and apparatus claims, and it was a Dutch auction, so the price sinks with time, and the first bidder to bid is a successful bidder. Of course, with the internet, people can be at different places, and there's latency in when they press a button and when that piece of data reaches the server. So the invention wanted each participant to provide a desired price and a maximum price at the outset, so the auction process was performed automatically somewhere else. Okay. Now, in this case, the board followed Convict and found that the technical part of the invention is essentially limited to instructing the server computer to apply the given conditions and perform any necessary calculations, and therefore both the method and the apparatus were deemed to be were refused for lack of inventive step. However, this decision does distinguish itself from the pension benefits and found that a method involving technical means is an invention within the meaning of Article 52.1, i.e. if you have some sort of technical feature in your claim, you won't inherently fall into the exclusions. And the convict approach is enshrined in European practice. It appears in the guidelines that every European examiner follows. So just to recap then, firstly you'd ask yourself, is the claim wholly excluded? Well, it would be if it's a pure business or mathematical method, but not if you have a technical feature. Any non-technical features are ignored and they're imported into the technical problem to be solved. Just remember that the EPO grants patents when a non-obvious technical solution to a technical problem can be identified. I'll just rush through some of these more quickly now. So let's move on to some practice with the claims. So you can claim a computer-implemented method, and as long as the claim is tied to some kind of technical feature, for example, to avoid, for example, the mental act exclusion, you need not recite a memory and a processor. And you do not need to recite the component which performs each element of the claim, like the memory module or the controller, etc. Computer program claims are allowed, and a wide range of formulations are accepted. And the computer program claim can cover transitory embodiments such as signal, and the claim can refer back to a method claim. Apparatus claims, the claims to apparatus are also allowed, and these two may refer back to a method claim. You do not need to recite the memory and the processor. And the claim can recite that the apparatus is configured to or operable to perform the state of functions or the method of another claim, i.e. not necessarily in use. So briefly then, a quick sort of framework for claims. So bearing in mind you have 15 claims at the EPA before you have significant excess claims fees, your first 12 claims could say be method claims in that sort of form. Then you may have an apparatus claim comprising a processor, then maybe a computer program claim, and then a computer readable medium claim, and you wouldn't need the, as I mentioned before, you wouldn't need the non-transitory limitation as per the US. This is sort of general practice now for claims. If you have like a distributed system with a client and a server, then claim the client and the server separately so they're not limited to being in the same jurisdiction. And then you can see here, pretend that you're a processor, claim what you're doing. And also computer program claims can be important for enforcement reasons, because would your claimed method be detectable in an infringer's product or service, but maybe the computer program would be. So very quickly now, in the description, if you tie features to corresponding advantages, that could help. You don't need to use the word effect or advantage. You could just say, for example, there the wheels enable the chair to be moved. Bearing in mind that there's very strict added matter provisions at the EPO, so always try and recite intermediate positions. There's nothing worse than when you try and amend a claim and all of a sudden you have to add every single feature in of the embodiment because there's just no intermediate position. So the summary at the EPO, I won't read that, but basically, technical and non-technical is non-defined. I remember that non-technical features can be ignored and they are often imported into the technical problem to be solved by the examiner. Okay, so moving on to the UK. The UK Patents Act is pretty much the same as the EPC. Program for a computer is inherently excluded, but not as such. The UK IPO is most definitely settled after this decision in 2006. The Aerotel test, so they're the 4 steps that you have to go through when deciding whether something is excluded. You properly construe the claim, you identify the actual or alleged contribution or novel feature, ask whether the contribution falls solely within excluded matter, and then check whether the contribution is technical in nature. And that is enshrined in the UK IPO practice with this patent, with this note that was published 2nd November 2006. So in rough terms, in the UK, you work out the contribution, then assess whether it's technical, and at the EPO, you work out what is technical and assess whether it is obvious. There was an example last year, Apple v HTC, multi-touch interface for a smartphone. The system was using flags to indicate whether a view on a touchscreen computer could handle single or multi-touch events. Now, this is an example where the Court of Appeal has moved a little bit towards the EPO, because the key question asked there was, does it solve a technical problem within the computer? So that suggests it's towards the EPA problem solution approach. And within that same decision, there were certain signposts given as to whether features and effects of a claim would actually be excluded. So the first signpost, whether the claimed technical effect has a technical effect on a process which is carried on outside the computer, whether the claimed technical effect operates at the level of the architecture of the computer, That is to say, whether the effect is produced irrespective of the data being processed or the applications being run. And there was a recent Symbian decision where they were sorting out a dynamic link library and basically made the whole system run more efficiently no matter what software was running on it. Number 3, whether the claimed technical effect results in the computer being made to operate in a new way. 4, whether the program made the computer a better computer in the sense of running more efficiently and effectively as a computer. And 5, whether the perceived problem is overcome by the claimed invention as opposed to merely being circumvented. You don't have to have all of these. 1 or 2 of them could be sufficient. So UK practice, all the standard EPO drafting practice points apply equally. But there's possibly less chance of getting cases through where the technical effect is wholly internal to a computer, and that's just because the UK IPO approach is slightly lagging the Court of Appeal, but hopefully they'll catch up. And so there's the summary, my last slide. The EPO tends to import the question of inherent patentability into inventive step analysis, whereas the UK imports the questions of novelty inventive step when considering inherent patentability. And so we'd recommend a tendency would be to file software applications at the EPO, but then again, there's always the question of how the UK courts will view validity of EP patents. Thank you very much.
Thank you so much, and I think we go